Hey everyone, we're going to get started in just a moment. We still have some registration folks joining us, so we'll give them a couple of minutes to get logged in. I'm going to give everyone just another minute to get logged in, and then we'll get started. Hi, everyone. I'm Lori Lapaki, and I'm one of the members of Aspirion's Thought Leadership Team, and it's my pleasure to welcome you all to part 2 of our complex claims series on cracking the code on motor vehicle accident claims. So just before we get started with today's session, I do want to cover a couple of housekeeping items. We really encourage you to ask any questions you have using the QA feature in the webinar. Please make sure you include the state where you're located, because that will have a bearing on our answer for your question. We're hoping to have time to answer questions at the end of today's session, but if we run out of time, or if there are any that we are not able to get to, we will answer them, and then we will send them out to those of you that registered for the webinar. You're also going to receive just a short 3-question survey at the end of the session, and we would really appreciate your feedback on both today's session and any ideas that you have for other topics that you'd like to have presented. Now, to kick us off, I do want to provide you with just a quick overview of Aspirion, just in case any of you are not already familiar with us. So here at Aspirion, we provide services to hospital providers of all sizes across the United States for the most complex segment of their revenue cycle. We focus on claims that need specialized investigation, billing, or resolution approaches like MVA, work comp, VA, and out of state, as well as claims that are difficult to get paid because of revenue integrity issues, such as the denials that we're all experiencing, but also underpayments, and then just generalized aged AR. We have a great team at Aspirion with the expertise needed to get these claims paid. That team consists of over 180 attorneys and legal professionals, more than 80 clinicians, and our technology experts, which include data scientists and engineers who are leading our developments in business intelligence, machine learning, analytics, and automation. We are excited to have Martin Drake and Josh McVey as our subject matter experts today for today's webinar. And so right now I'm going to turn it over to them to introduce themselves and to give you some information about their experience. So Martin, why don't we start with you?
Thanks, Lori. So I'm Martin Drake, and I'm the Senior Director of Complex Claims Legal at Aspirion. I head a team of complex claims attorneys here. I've had a unique journey to get here, and I've seen kind of all sides of the MVA universe. I actually started working for the law firm with Lori back in the summer of 2007, from which Aspirion was originally born. Worked there summers during college and all through law school, and that was my first job out of law school, where I did Aspirion's legal work for about a year. Then I went out and did insurance defense litigation for 9 years, also handled a little bit of plaintiff side personal injury work as well, and then was able to return to Aspirion 2 years ago to join this great team. I'm going to turn it over to my co-presenter, Josh, now.
All right, thank you, Martin. Yes, my name is Josh McVey. I'm the general manager of the MBA service line here at Aspirion. I have over 15 years of motor vehicle specific experience. In fact, those entire 15 years are solely focused just on motor vehicle accounts. I'm located in Denver, and that's where I began my career 15 years ago, actually factoring motor vehicle claims. For those of you that may not know what I'm talking about when I say that, back in the early 2000s, Colorado went through a few law changes with tort reform. And as a part of that, it left many accident victims uninsured and without a way to obtain medical care that they needed. So through that, our company would step in and we would help fill the gap by funding the treatment that these uninsured accident victims needed. We would hold the lien for those expenses that we paid out and that we incurred, much like what a hospital does. And then we would get repaid at the time of the patient settlement by working directly with the plaintiff attorney. And so that was the first 5 or so years of my career. And then after that, 5 years of factoring, we were approached by a couple of local hospitals that we had worked with through this process, who had asked us if we ever thought about changing our focus from and becoming an outsourced vendor partner. It wasn't long after that we founded, what was at that time, Continuum Health Solutions, where we grew our technology, our experience, well over a decade, and then merged here just last year with Aspirion so that we could give our hospital partners the best-in-class MBA program between their experience and ours. So that's a little bit about me and my background, and so I'll turn it back over to Lori now to walk through today's agenda.
All right, thanks, Josh. So today, I think Josh is going to walk us through just a real quick recap of session 1, just a couple of the takeaways that we provided in that session. And we're going to continue the example that we had there with I think some of you may remember Bob from the first session. And then we're going to talk through some different scenarios that have to do with that example, with some allegations and some litigation that Bob received on his claim. Then we're going to walk you through our recommendations. These are going to be more focused on the legal side of MBA, TPL collections, recommendations that have to do not only with your lien filings, but also with your negotiations. And then, as I said earlier, we're hoping to have time for Q&A there at the end. So I'm going to go ahead and hand it back over, I believe, to Josh.
All right, thank you, Lori, and welcome again, everyone, here for session 2 of Cracking the Code for Motor Vehicle Accidents. Like Lori said, we're going to start here with a little recap of where we left with session 1, just to bring everyone up to speed. And so in session 1, we met Bob, who is a revenue cycle director at a local hospital. So Bob knew MBA wasn't a primary focus of the hospital, but overall, he thought they were doing a pretty good job. So one evening, as Bob was watching the news, he saw an update about a multi-car pileup accident that happened in his local town. And Bob, at that point, wanted to know how the financial outcome was of his hospital. There were a lot of injuries reported. He knew that a few of those patients had treated there at the hospital. And so Bob decided the next day that he was going to go in, do a follow-up, and review those 4 accounts. So let's look at what Bob found when he did that review. So Bob found 4 different patients from that accident that had treated at his hospital. So let's recap each patient, what he found, and where they ended during session 1. Patient 1, the patient access team had identified patient 1 as a motor vehicle account, and had asked him for his coverage, and to which, at their surprise at that point, they were yelled at. They were told, "It's not my fault. You should bill the other guy. I'm not giving you anything." Right, so then at that point, patient 1 was treated. He left the hospital upset. He did not provide any information to them at all, continuing to push them back to the at-fault party. And after multiple follow-ups by Bob's hospital team, they ended up putting the patient in collections. And to when at that point, they began getting threatening emails and calls from his plaintiff attorney, threatening the hospital to be sued, to which in the end, negotiations returned the hospital only recovering a self-pay rate of about $312 on the original $3,900 bill. So with patient 2, that patient we found was a minor who had been a passenger in a friend's car that was hit by someone else. The minor's guardian was not the insured in this scenario, and he did not know what insurance to provide the hospital. So because of the confusion of the setup and who the patient access team thought they were supposed to bill, patient 2 also left with the guardian, left the hospital without any known coverage information. The hospital follow-up team then got involved. They had a little bit more success than in patient 1. They found health insurance and they were able to get that billed out. But unfortunately, as I'm sure all of you have seen at some point, that patient's health insurance denied. And they claimed saying, hey, there's a primary MBA coverage, you need to go build them. So follow-up team went back to the guardian trying to find out who the MBA coverage was. And in this scenario, they were not able to get a hold of the patient's guardian again. And by the time timely filing rolled around with the hospital's known health insurance coverage, it was too late. And they ended up having to write this account off to zero, not getting any payment on it whatsoever. With patient 3, we found that there was no involvement, or excuse me, the patient access team did not ask for about any involvement in the MBA accident. This patient slid through without any questions whatsoever. It was registered as her Medicaid primary coverage. They sent the billing to Medicaid. Medicaid went ahead and paid it without any questions. And then the hospital recouped the standard repayment on that bill of just $1,350 on the patient's $9,000 bill. Then we got to patient 4, where this was really the registration's golden child, right? This is the one that Bob got excited about. He was happy to see that from the beginning to end, this one looked exactly how it was supposed to. The patient access team had registered with a primary MBA MedPay coverage. They were given a secondary health insurance coverage, and the patient even knew who the third party was that hit him. So they were able to register that tertiary liability insurance coverage as well. So because they did such a good job and had an expedited discovery process and billing process, the patient's MedPay was billed. They received a full $5,000 balance of his benefits, which then exhausted the benefit, and they billed the remaining balance to the patient's health insurance. With this scenario, the patient, their health insurance had actually lapsed, and so they received a denial back saying that this was not a valid coverage and that they were not going to be issuing any payment. At that time, thankfully, the patient access team, like I said, had already found who the at-fault tertiary party was. So they simply filed a hospital lien in that case and moved the remaining balance to begin pursuing the third-party liability claim. So you might also remember that after this review that Bob discovered that there had been a lot of turnover in his patient access department, and they really hadn't done the proper MBA training that he had expected or hoped for, and that we brought recommendations to at that point. So following those discoveries, we walked through in session 1 what those 7 recommendations were for a successful MBA program that Bob wished he would have known and had already implemented. So let's do a real quick recap of what those 7 recommendations were. Okay, recommendation number 1 was to train your patient access teams. We all know that this can be a high turnover position, so ensure that you have a regular MBA training cadence that both teaches new staff as well as refreshes tenured staff. Not a lot of claims are always coming through your ER, so even your most tenured staff can use a good refresher course once in a while on motor vehicle claims. Recommendation number 2 was to identify all MBA related accounts. So don't forget that MBA accounts can pay up to 100% of billed charges. So it is important that you identify all of the MBA accounts that you can. The recommendation we provided was to back up your registration process with either a V-code report and or work queue, depending on your EMR, that would allow you to identify whatever accounts may have been missed at registration so you can recover at the highest potential revenue point possible. Recommendation number 3 was to devote resources to investigate all your potential payers. Again, remember, your MBA benefits are a first come, first served basis, so investigate them quickly and use resources to assist in the discovery process. You need to have dedicated focus on that. Recommendation number 4 was to coordinate all coverages appropriately. So every state has a potential to have a slightly different coordination of benefits and or statutory requirements that may drive your billing order. Make sure you understand what your state requires, as well as what your your contracts are as it relates to motor vehicle accident benefits. There are some contracts that will require it to be primary, others possibly secondary. So make sure you know how your contracts play out with MBA coverage in your state. Recommendation number 5 was to bill according to the payer preference. So as we noted, not every payer can actually accept electronic claims when it comes to motor vehicle accounts. And even if they can, it may not be their preferred method for quick payments unless required by the state. So our system, as we spoke to, is built out with thousands of property and casualty payers and their specific billing preference. So for example, rather that is mail, rather it's fax, maybe it is electronic. If you know what your payer's primary and preferred preference are, then you can expedite the bill payment and receipt process with them and see those funds come in even sooner. Okay, recommendation number 6, that was to review your payments. So all payers, inclusive of motor vehicle, are trying to find a way to reduce and or deny payments. That is nothing new to any of us. But with MBA, make sure you're pushing back on any inappropriate reductions, such as the regular and customary, as well as voluntary networks. Push back on those. Make sure those agreements are not being accessed for MBA. If they are, look at your contracting department to see if you can remove motor vehicle out of those contracts. And additionally, you want to ensure that within no-fault states that they are properly paying if they have an allotted fee schedule. So ensure that you keep your fee schedule up to date, that you know the most recent one, and that those payers are paying appropriately. Send appeals as necessary. And finally, the 7th recommendation that we gave you in the first session was to track your results. This is really important that you know your performance and that you're tracking the appropriate KPIs and benchmarks. Don't get caught up on percentages or indicators that don't track the proper metrics. So know where you're at in your state, what you should be going after, and what the appropriate KPIs are in order to track your recovery and your results appropriately. And back to Bob to kind of close us up on this recap this afternoon. As you might recall, Bob had left frustrated after his review of the hospital's financial performance and all the amount that he missed of collection opportunity because they did not have the appropriate focus on their MBA program and had not been following those 7 recommendations that we just provided. Had Bob followed those recommendations, we had learned last time that his team would have collected in excess of $12,000 on these 4 patient accounts alone. And only one of them, unfortunately, patient 4, is still open and moving towards a TPL settlement. Reminder, patient 1 had a MedPay policy that would have paid at a full bill charge or a $3,900 recovery. Patient 2 would have paid at the hospital's commercial insurance rates after the hospital obtained the MedPay denial, had they been able to get that from the patient. In this case, that health insurance recovery would have been $5,250. We found with patient 3 that they also had a MedPay policy that could have exhausted at a $5,000 benefit and received an additional more than $3,000 than what Medicaid would have paid on that account. And as I noted, we left patient 4, who had been registered appropriately, billed appropriately, and followed up on correctly in pursuit of a third-party liability settlement. And so now I'm going to turn it back over to Martin, where he's going to guide us through patient 4 and what happened moving forward.
Bob had taken comfort with the fact that one of the 4 patients from the high-profile motor vehicle accident had been identified and investigated correctly. We'll look at the numbers more closely at the end of today's session, but this patient had a $50,000 hospital bill. So this is a big account that we're dealing with here. You'll recall that MedPay was filed and paid $5,000, and the balance was secured with a hospital lien following the hospital's normal process. So Bob was expecting that the balance of the bill would be paid after several months, and he put the account on hold. But instead of getting a payment, Bob's boss CFO Frank received notice that the hospital was being sued because of the hospital lien. This is an increasingly common scenario that hospitals face. So let's look at what the lawsuit is alleging against Bob's Hospital for filing this lien. So the first thing that the attorney for patient number 4 is alleging is that the hospital lien that the hospital filed was invalid. Second allegation is that the bills that secured the lien were not reasonable and customary. The third allegation is that the use of the charge master rates to secure that lien was actually fraudulent. And then the fourth allegation is that filing of the lien based on the charge master rates was actually an unfair and deceptive trade practice violation according to the state law where Bob's Hospital is located. So let's look a little deeper into each one of these allegations individually. So the first thing that the attorney for patient 4 alleges in the lawsuit served on Bob's Hospital is that the lien is invalid because it doesn't comply with the requirements of the hospital lien statute in that state. We're going to discuss more in depth in a moment, but the primary allegation here in this lawsuit is that the hospital did not put the tortfeasor on the lien. For those of you not familiar with that term, the tortfeasor is the person or entity that the patient claims caused the accident and led to that patient's treatment. Now, every state's going to have differing legal requirements to file enforceable hospital liens, and even states that border each other could have completely different hospital lien laws. So you're really going to need to familiarize yourself with your state-specific hospital lien laws when you're looking at running a successful MBA program. So when you are looking at filing hospital liens, you need to be very familiar with your individual state's hospital lien laws and court cases that interpret those state lien laws. And if you're with a bigger system that has facilities in multiple states, you're going to obviously want to make sure that you're familiar with the hospital lien laws and those court cases interpreting them in all of those states. So some of the things you're going to want to look at when you're looking at your state's law for perfecting a hospital lien is, are you in a state where you have to actually file the hospital lien with a clerk of court, or can you simply mail the lien out to all of the interested parties by certified mail? So states where you would have to file the lien would include Colorado, Texas, Georgia, or states where you can simply send a certified mail notice would include California, Missouri, and Illinois. You're going to want to look at what information must be included in the lien. Attorneys challenge liens based on this all the time. Of course, the patient information and address is going to need to be in there, but some states require that you put the tortfeasor, and some states have even differing requirements as to whether the tortfeasor must absolutely be listed or if there's some kind of standard of, to the hospital's best knowledge, as to who the patient claims to be the tortfeasors. What kind of deadlines are you looking at when you're having to file and perfect these liens? In some states, you have as little as 10 days after the date that the patient's discharged to file and perfect your lien. States like Georgia, you have 75 days after the date of discharge. In states like Missouri, Texas, Colorado, you have up until the date that the patient settles his or her personal injury cause of action to file and perfect the lien. When you're looking at how strictly you have to comply with your state's hospital lien statute to perfect the lien, are you in a state that the courts have interpreted that hospital lien law as requiring what's called strict compliance? Meaning if you don't comply with subsections A through D, then the lien is automatically invalid. Or are you in a state where the courts have said, well, you complied with subsections A, B, and D, so that's what we're going to call substantial compliance. We're going to go ahead and hold that the lien is enforceable. And the last thing you're going to want to look at is going to be, what does it cost to file these hospital liens? Are you in a state like Washington State, where it's $100 to just file the lien? You have to renew the lien every year at another $100, and then you have to file a cancellation of the lien after the patient settles their BI cause of action. So you're in $300 for just one lien. So these are all things that you're going to want to think about when you're looking at filing liens. So let's continue to look at the allegations in the lawsuit against Bob's Hospital. So patient 4 alleges that the charge master rates on which the lien were filed are not reasonable and customary. So why did he allege this? Most hospital lien laws contain some phrase that the charges which the lien secure must be reasonable and or customary, otherwise the lien is not valid. The reason for this is the legislatures don't want hospitals filing a lien on a $15,000 MRI without contrast at one level. So personal injury attorneys have been suing hospitals to have liens extinguished or to have the courts decide the reasonableness of the charges for decades. In those lawsuits, both the patient and the hospital have to present evidence, usually through expert witnesses, to establish the reasonable and customary amount of the charges. However, in the last decade, personal injury attorneys have sought to compel hospitals to turn over their managed care contracts with commercial and governmental payers to compare the rates that hospitals accept to argue that the charge master rates are not reasonable. Now, unfortunately, both the Supreme Court of Georgia and the Supreme Court of Texas have held that hospitals can be compelled to produce these agreements in discovery in these lawsuits. No hospital wants to have to produce these payer contracts. They contain confidential and trade secret provisions. You have to have your attorneys review and redact them, and it's just a giant mess to have to go through that process. And also, arguably, the rates in these contracts are irrelevant as to how your hospital computes its charge master rates. What the hospital will accept from a commercial or governmental payer, where there are discounts for volume and promises of prompt and full payment, have nothing to do with the cost of treating an uninsured or self-pay patient. The third allegation in the lawsuit against Bob's Hospital is that the lien filed on the charge master rates is a violation of that state's Deceptive Trade Practices Act laws. We've seen an uptick in letters from personal injury attorneys in Texas arguing that hospital liens there filed based on the full charge master rates violate the Texas Deceptive Trade Practices Act. If you encounter an allegation like this, it's best to consult with an attorney licensed in your state that can review your state's deceptive trade practice law and advise you about those allegations. The fourth allegation is that the lien based on the charge master rates actually amounts to fraud. So there was litigation here in Georgia that went on for years, including a class action. And thankfully, in 2020, the Supreme Court of Georgia held that simply filing a lien based on the charge master rates did not amount to fraud. Unfortunately, this is not going to stop attorneys in different states from making the same arguments. So personal injury attorneys send these full freight charge master charges to the insurance carriers when they're negotiating the insurance settlements to secure the personal injury settlement. But then when it's time to satisfy the lien, they turn around and argue that the hospital's charges were unreasonable. It's not a logical, and frankly, it's not a fair position to take. The charges were perfectly reasonable when they were used in the demand letter that the attorney sent to the liability carrier to secure the settlement. So why should they be allowed to talk out of the other side of their mouth when it comes to satisfying the lien? There's been some different approaches to this. In Texas, there was litigation where where a hospital argued that the patient ratified or had adopted or approved of the charge master rates as reasonable because his attorney had used those charges in several documents, including the demand letter sent to the insurance company, discovery responses in the lawsuit, and the release to end the lawsuit. So that's just one way that a hospital can use creative lawyering to get around some of these allegations. Another legal theory could be used is estoppel. So the argument there is the patient submitted the charges to the insurance company to secure the settlement. They shouldn't be allowed to subsequently argue that the charges are not reasonable and customary. There's not any reported decisions on that issue yet, but that's an issue that we're monitoring pretty closely. So now we're going to get into some specific recommendations, as Lori mentioned earlier. So the first recommendation that we're going to talk about for an effective MBA program when we're looking at this legal landscape and filing hospital liens is to know your state's legal structure. There are two basic MVA legal structures in this country. So there are tort states where there's no requirement for drivers to have first party, no fault coverage. And then there are no fault states where there's a requirement to purchase no fault first party coverage. So as you can see in tort states, the claim has to be made against the at-fault party. Drivers are all required to carry liability insurance. You can make claims for medical bills, wages, your pain and suffering. In these states, the optional first-party coverage, such as med pay, personal injury coverage, can be purchased, but it's often not required. So that's something to always look at in your state. If you're a tort state, is med pay or PIP optional, because it still can help you with your reimbursement. At Aspirion, we've always recommended pursuing this first party coverage in tort states because it can pay for a significant portion, if not the full balance, of your smaller ER charges. The majority of states do have a hospital lien statute, including the District of Columbia. There's a handful of states that don't have them. So then when you're looking at the no fault states, this is where you've got to use your own coverage for your own damages. The claims against the at-fault party are going to be limited because you're going to have to meet the threshold for the patient's damages based on that state's mandatory minimum limits for that first party coverage. So for example, in Florida, where there's a minimum $10,000 in first party coverage, the patient would have to have 11,000 or more before they can make a claim against the at-fault party. You're going to run into issues in states like these because fee schedules may apply. Unfortunately, a lot of times those are tied to the workers' compensation rates. So there could be limited reimbursement there. Liens are available in some of these states, so that's something you still want to look into. Historically, it's been our perspective at Aspirion that while initially we thought that liens may not be that useful in no-fault states, they still are very useful because you're still going to have patients that have bills that exceed the minimum first-party limits, and you're going to want to secure your charges for that TPL that kicks in after the minimum first-party limits have been paid. So as you can see, there's a few states here, Florida, Michigan, Massachusetts, North Dakota, Utah. So the second recommendation that we're going to talk about is understanding liability and the other coverages that are going to be available for the patients to reimburse the hospital for treatment. So there's two basic types of insurance coverage when we're dealing with MVA. There's your first party coverages like MedPay or PIP, and there's third party liability. First party coverage, for those not familiar, is insurance that a patient purchases, and third party coverage is insurance that the at-fault party will have purchased. Uninsured or underinsured motorist coverage is a first party coverage that the patient purchases, but it works similar to third party in that it comes after MedPay or PIP and liability if it's available when you're looking at that coordination of benefits. So as you can see, some of the benefits to the first party coverage is it's typically going to have a high reimbursement rate depending on if there's a fee schedule or not. It's typically going to be primary to health insurance. There could be multiple policies available that could stack. It's typically going to pay quickly. It's going to apply to all vehicle-related injuries, which may not be your typical car accident that you would think of, but any injury relating to use of an automobile. There's not going to be a determination of fault that the insurance companies and or the courts are going to need to make. So with liability coverage, you're also looking at a high reimbursement rate, and you're typically not going to be tied to any fee schedule there, depending on state law. Some of the cons with pursuing the liability coverage, there's going to need to be legal resources as far as filing liens, keeping up with the patient's legal claim process so that you can secure payment after the patient has settled their claim, which could take a year or two. There's other costs such as lien filing. As I mentioned, you've got to wait for the settlement to occur. In a lot of states, there's a 2-year statute of limitations for the patient to file his or her lawsuit after the accident has happened. A lot of patients will wait that full 2 years. Ask me how I know from my former insurance defense days. And then you have another year or two of litigation that can occur. It's not guaranteed. The patient could lose at trial, or the insurance company could refuse to settle. And then, as we'll discuss later, there's legal risk for hospitals when you are pursuing those third-party liability coverages through a lien. So the third recommendation that we're going to cover is understanding hospital liens. So if your hospital is located in a state where there is a hospital lien law, it's a great tool to help your reimbursement, especially when you're treating uninsured patients. So most here should be familiar with hospital liens, but for those who are not, it's a legal filing that secures payment of medical bills of a person that's injured by fault of another from the insurance proceeds or a jury verdict if they go all the way to trial. So these are not liens that attach to the patient's property. You can't use them to garnish wages like a collection action. Each state's law will typically define them as attaching only to the patient's personal injury cause of action. Unfortunately, most patients aren't going to understand this, and this is something that is going to have to be explained to the patients, whether it's your intake staff at the ER or if you have a third-party vendor or business associate like Aspirion. So why should hospitals utilize liens? Well, with the uninsured pure self-pay patients, it's often the only way to secure payment for treatment. Hospitals have duties under EMTALA when the uninsured patients present, so the liens help to compensate hospital for those efforts. Deciding what situation liens should be filed in is going to be heavily dependent on state law. So for uninsured or self-pay patients, you're going to typically always want to file a lien in those situations. We'll discuss in a little while the legal risk of filing liens where the patient has commercial health. But what about when the patient has a governmental insurance like Medicare or Medicaid? Or what if the patient has a high balance left over after commercial health is paid? You're going to need to look at your individual state laws in those situations because it's going to be highly dependent on state law. Now, a feature that nearly all lien laws has is the ability to enforce the lien if the personal injury attorney doesn't satisfy the lien once the settlement occurs. The entire point of the lien and securing the charges is to have the leverage behind that to make sure that you get paid. So litigation could be possible, and that's an available tool to hospitals depending on your state law if the personal injury attorney or the patient doesn't do the correct thing and satisfy the lien out of the settlement proceeds. And then if you're in a state where there is no hospital lien statute, you should look into whether your state's law allows for what's called a letter of protection to be entered into with patients to secure treatment for services. It's not a legal filing, but it's a voluntary agreement. So the fourth recommendation that we're going to look at is to be aware of the state statutory changes that affect hospital lien filing. So earlier we discussed learning your state's laws on liens, but you also need to monitor for changes in state law as new and amended laws can change how you perfect hospital liens. So the example that we're using in this slide is based on a real case that we had here in Georgia. A lien was challenged for not listing the tortfeasor, and the issue became what level of effort did the hospital have to expend to try and learn the identity of the tortfeasor? If your state requires the lien to list the tortfeasor, how do you learn that person's identity? Does the patient, if the patient knows who the person was that caused the accident, then that's great. But if the patient doesn't know the name of the person that caused the accident, you're going to have to look elsewhere. The next best source may be a subscription to an insurance claims database service, but what if you don't have access to that kind of database? Then the accident report is probably going to be the next best source of information for the tortfeasor. Fortunately, it's becoming increasingly difficult to obtain accident reports depending on state law. Other good resources could be contacting all available insurance, first and third party, the patient's attorney. You may have to go through all of these avenues and still not be able to learn the identity of the tortfeasor. So then you need to look to your state law to see if there's a requirement that the hospital show some level of due diligence to show that it attempted to substantially comply with the lien statute. So this example, Bob's team was unfortunately unaware that their state's hospital lien law required some level of effort be made to learn the identity of the tortfeasor, and that spelled trouble for the lien, as we'll go into later. There are a myriad of other legislative changes and court cases interpreting hospital lien laws that are affecting hospitals. Not only can changes in the law risk hospital liens being challenged and hospitals miss out on opportunities to collect revenue, they can also lead to legal risk in the forms of lawsuits, including class actions. Hospitals could be liable for money damages in litigation for not following the lien laws, and they can also incur substantial attorney's fees in defending these lawsuits.
Yeah, and thank you, Martin. That's a great call out. And with that said, I want to jump in and speak about a trend that we're seeing in it with an increasing number of states requiring changes of hospital liens to require health insurance be billed prior to filing the lien. So it has always been our approach to be a little more conservative here in this area as we try to find our hospital partners the fastest avenue to cash. So although the patient has health insurance coverage, we have always recommended billing it secondary, regardless of whether your state's law specifically calls out this requirement or not. So we saw this play out here in Colorado when our hospital lien laws were amended back in 2015 to require health insurance to be billed prior to a hospital lien being filed. The statute was not clear specifically as it related to the billing position of Medicaid and Medicare. So we took the position along with our internal and external legal counsel, our hospital partners legal counsel, and discussed where we landed on this topic. We decided with our partners at that time that we would also move Medicaid and Medicare into that secondary position so that our hospital partners would not risk any potential downstream litigation that we saw as potentially coming due to the non-clarity of the law itself. And as we suspected, in short time, litigation did occur, and that lien law was later amended to specifically call out Medicaid and Medicare as having the requirement to be billed prior to a hospital lien being filed.
That's right, Josh. And in Colorado, if a hospital fails to bill health insurance before filing a lien, unfortunately, the patient can actually sue the hospital and get damages in the amount of 2 times of the hospital bill. So last year, for example, I had to speak with an attorney in Colorado because a hospital didn't know that the patient had health insurance. It filed a lien, but after being informed that the patient had health insurance, it billed health, got paid, and canceled the lien. The attorney still threatened suit, but ultimately did not file suit. And just for the purpose of numbers to show the impact of this, that patient's bill was over $37,500. So the patient could have sued the hospital for $75,000. Georgia became the latest state last July to pass an amended hospital lien law requiring that health be billed before a lien can be filed. So this is a trend to watch across the country. As we'll discuss in a moment, there can be a real risk associated with pursuing liens instead of filing commercial health insurance. What happens when your state passes a law that requires that health be billed before a lien is filed? Does that mean only commercial health, or does it include the governmental payers? The statutes are often vague and provide no guidance, so it's often been up to the courts. So federal law and regulations are typically going to state that Medicare, Medicaid are payers of last resort, which would allow liens to be pursued until timely filing runs for patients with those coverages, but courts in different states are handling that issue differently. Supreme Court of Colorado unfortunately held that federal law did not preempt state law requiring hospitals to bill health before filing a lien. So hospitals in Colorado have had to bill Medicare instead of being able to file a lien on those patients. Still don't understand or agree with that decision, but that's the reality of differing state Supreme Courts deciding these issues. Thankfully, the Court of Appeals in Texas reached the opposite conclusion and held that federal law did preempt the state law from requiring hospitals to bill Medicare before a lien could be filed. Here in Georgia, because the law is so new, the appellate courts haven't decided this issue yet, so it's something that we're monitoring closely. So this is an example of a legal risk associated with pursuing hospital liens. instead of filing with commercial health, and it's a great teaching case. So this occurred in Arkansas. It went on for several years and just resolved last year. So unlike some of the other states we've been discussing recently, Arkansas law does not actually require health to be billed before a hospital can file a lien. So there was a patient, a firefighter, and remember, optics are going to matter when you're dealing with patient experiences. You're going to want to think, how is this going to play out on the evening news or the local newspaper? So that firefighter had commercial health. The hospital refused to bill it, filed a lien, and that lawyer, the lawyer for that firefighter, got a class action together involving similar accounts. That litigation went on for 5 years, back and forth between multiple courts. Just imagine the attorney's fees that it costs to defend all of that. And at the end of the day, after 5 long years, a settlement of $3 million was reached to settle that class action, a hefty sum on top of all of the other legal fees to get to that point. Another legislative trend that has been affecting hospital lien filing are states that are passing their own versions of the Patient Protection Act, similar to the federal law that went into effect in 2010. So why this is relevant, these laws deal in part with what the law refers to as extraordinary collection actions. Those are typically defined as a collection lawsuit against the patient, placing a lien on the patient's house, garnishing wages. But depending on how the state Patient Protection Act is worded, it could be applied to filing hospital liens. Originally, the federal legislation didn't clarify if hospital liens were considered an ECA, but the subsequent implementing regulations did specifically exclude hospital liens from the definition of an extraordinary collection action. So why is this a trend to watch? Because state enacted patient protection acts can interfere with a hospital's ability to file hospital liens like we saw in Idaho the last several years. When Idaho's legislature passed its PPA in 2019, it was silent as to whether hospital liens were considered an extraordinary collection act. That led to legislation, and at least one hospital was prohibited from filing hospital liens for several years after that. Thankfully, this year, Idaho's legislature amended both its Patient Protection Act and its hospital lien statute to allow hospitals to safely begin filing hospital liens, again, without running firm of the Patient Protection Act there. Another thing to look for here is the National Consumer Law Center in 2019 put out a document called the Model Medical Debt Protection Act. And this contains language that would restrict filing of hospital liens. And it looks as if several states are looking to this model act when they're drafting their model acts. Next slide, please. So some suggested strategies here, because I believe personally that patient protection acts are probably coming to a state near you. The first thing that you're going to want to do if you're with a provider is to fight any proposed statutes, contact your legislature, your state hospital association, fight any proposed legislation that's based on that Model Medical Debt Protection Act. The other strategy that you're going to want to employ, if it does look like more likely than not that your state's going to pass one of those PPAs, is to follow the models that we saw in Colorado or Oregon. So Colorado is the ideal approach because that's Patient Protection Act there explicitly excludes hospital liens filed under state law. Oregon is a similar good method because instead of excluding liens from the definition, it says that the definition of an ECA is basically the same as the federal version. And so then you have to look to the implementing regulations and you find that liens are excluded. So those are the strategies you're going to want to follow if you're in one of those two states. So recommendation number 5 is going to be hospital lien enforcement. We've already touched on this earlier, but I'll go into a little more detail. So one of the main reasons that liens are such an effective tool is that they can be enforced through litigation. You need to check your individual state law, but most states allow hospitals to sue to enforce the hospital liens. So who do you sue in this situation? Oftentimes you can sue the tortfeasor, but most individuals are going to be judgment proof, meaning you can get a judgment against them, but they're not going to have enough money to satisfy the hospital lien. Plus, they were probably already covered by some form of automobile liability insurance. Now, a number of states will allow the hospital to sue the responsible insurance carrier, which is ideal because they have deep pockets. And it's much better from an optics standpoint. Remember the example earlier with the firefighter? So in that instance, you're not suing your patient on a straight debt collection action, or you're not suing the individual tortfeasor. Oftentimes, the insurance company will bring the patient and their attorney into the lawsuit through some form of third-party action, because it's typically the attorney or the patient that led to the lien not being satisfied in the first place. But again, in that scenario, it's the insurance company suing the patient, not the hospital. Optics always matter. And as with anything, you need to look at costs. So does your state allow for attorney's fees to be recovered when you have to sue the insurance company to enforce the lien? And if not, what kind of threshold do you want to set for liens that you're going to sue on? Do you only want to sue to enforce $100,000 liens, $10,000 liens, or $1,000 liens? And does that make sense when you're looking at the cost of hiring an attorney or third-party vendor? So we're going to turn it back over to Josh to cover recommendation number 6.
Thank you, Martin. And with recommendation number 6, use reasonable negotiation tactics. Now, this recommendation often surprises many of our hospital partners, right? So yes, liens do give you leverage, and yes, there's legal authority behind them, but it doesn't mean that you're going to get paid out of 100% of billed charges every single time. In fact, if you choose to enforce a lien with a hardline stance, you're often going to put your hospital at risk for legal action. So every claim must be evaluated on its own merit, and you cannot expect the same outcome every single time. So negotiations are just that. They're negotiations. It's not your opportunity to stick it to the attorney and get everything from the entire settlement that came out. In most scenarios, you're going to have to take a reduction of some sort, and that is okay. Now, on the other hand, it does not mean you have to accept the reduction request of the attorney every time. Again, it is a negotiation. You can go back and forth. Now, one of our recommendations is to actually build a positive relationship with the personal injury and plaintiff attorneys. If they know that you are reasonable to deal with, they're more likely themselves to not draw hardline stances or go straight to threats of lawsuits, which we've seen on multiple occasions. In fact, when partnering with a new hospital or health system, we will often go and meet with those local plaintiff and personal injury attorneys in our hospital partners general area and try to ease any negative relationships and or frustrations that may have already been formed over time.
And Josh, that's a great point. Just anecdotally speaking, what I do a lot of every day is I deal with these patient personal injury attorneys. I tell them, look, my cell phone is in my email signature. If you have any issues with negotiating one of those liens, just reach out to me directly. And I've seen firsthand law firms that have been routinely filing lawsuits against hospitals to extinguish the liens are now thankfully reaching out to me directly, and we're getting liens resolved. So it's a great tactic to use.
Yeah, thanks, Mark. Because like we say, nothing is wrong with building positive relationships. It will go a long ways. So let's step into how do you know what the right amount is? First of all, like I just mentioned, you have to evaluate each case on its own merit. Just because you get 100% of billed charges on a previous case doesn't mean that you're going to on the next case. And the reverse is also accurate. Just because you took a reduction on a case today doesn't mean you may need to take a reduction on a case tomorrow. Everyone has its own limits, its own merits. So secondly, don't assume that the patient's attorney has exhausted all avenues of payment. As part of your upfront identification discovery, a lot of what we covered in session 1, make sure your team is looking for all coverages. Some of those are MedPay, maybe other health insurances, an underinsured or uninsured policy, an umbrella coverage, coverage from the driver's policy if it's different, All of those are areas that could potentially allow you to find more coverage to help pay your bill, some even before you dig into the settlement negotiations with the attorney. Next, once you've ensured all avenues of payments have been exhausted, you need to ask for and verify all the settlement information. This is going to be key in determining what the amount is you could potentially get repaid and if it's the right amount or not. So look at the liability limits of the case. Did they settle for the max amount? Is it less? Can you confirm what it was the attorney settled for? What are the other medical expenses? They may not have just treated at your hospital. What if they were flown flight for life case? Maybe brought in an ambulance. Maybe they've gone to a couple different hospitals for physical therapy or imaging. Look at all the other medical expenses that are also potentially on a lien. Wage loss can be brought into the scenario of how much work did they miss during their time of recovery and treating. The patient's recovery and their current condition. Are there going to be a lot of additional bills downstream? Are they, impaired for a lifetime? What were the extent of the accident that has caused this injury to the patient that you treated? And finally, look at the attorney's fees. Now, one thing to note is that the attorneys do not legally have to reduce their fees, as their agreement with the patient is going to have priority over the lien. Now, that said, it does not mean that you shouldn't ask them to reduce their fee. And what we say is share in the reduction, but it's not always something we can force. So if they put their hardline stance there and tell you no, it may be something that you're unable to do anything else with. So as you take all these factors into consideration, simply ask yourself, is what I'm asking for reasonable? Do all the numbers add up? Have I taken all of this into consideration? And something Martin mentioned earlier, how would it sound in the evening news or if read in the newspaper with what your negotiation tactics were and what you're asking that patient and that attorney to repay you out of the settlement? In the end, you can determine what the attorney and the patient can reasonably pay towards your medical bill by knowing all the settlement details and things noted above, as well as by doing some simple math to figure what portion of that settlement can be used for medical bills. And finally, look to your hospital's charity care to be a potential option. There may be times with catastrophic injuries and accidents where that patient's injuries are going to incur extremely high and more than normal bills. They're going to have excessive lost wages, and they're going to need a lot of future care. We've all seen these kind of large catastrophic accidents come through our hospitals. That person may have, the at-fault party may have a minimal policy limit only at $25,000, $30,000, potentially more, but it could keep your hospital and all the other medical providers that treated alongside you from recovering much in that settlement. Don't hesitate to review your charity policies and see if that is an option for repayment and care on those type of cases. And in the end, just remember, negotiations, if they come to an impasse, will often end up in a legal action. Make sure you're being reasonable in your settlement approach.
So to close up today, because we're almost at the top of the hour, let's check back in with Bob and see how this lawsuit challenging his lien affected collection of the lien in that case. So patient Ford had a $50,000 hospital bill, and he had $62,000 in total medical bills. He received a $125,000 settlement, $25,000 from the liability policy, $100,000 from his own underinsured motorist policy. The hospital had billed and received $5,000 in med pay, so the balance that was secured by the lien was $45,000. Unfortunately, because Bob's hospital didn't show the required amount of due diligence effort in trying to learn who the tortfeasor was, the insurance company was able to pressure the hospital into settling for a nominal amount to dismiss the lawsuit. So the lien balance could have been paid in full by the available settlement, but the hospital was stuck with only receiving a nominal amount. So you can see how the intersection of the legalities of filing hospital liens and your bottom dollar collections are going to be impacted by all of these factors. So we've covered a great deal of information today. So now I'm going to turn it back over to Lori to see if there's any questions today.
thanks, Martin. So we do have several questions in here. I know we're right at time, so I don't think we're going to be able to have time to, maybe we can just do one of them live and then the others we'll send back out. Do you have to have an attorney on your hospital staff in order to file liens? Martin, is that one you want to take real quick before we close?
Yeah, that's a great question, Lori. So like everything else, I apologize if I'm repeating myself at this point. That's going to be very dependent on state law. You're really going to want to consult with your hospital's general counsel or outside counsel licensed in that state. There's certain states such as Kansas, Utah, New Jersey, where a lawyer licensed in that state is typically going to be needed to file the liens, but there could be other states where you're not going to need a licensed attorney to send the lien out, especially some of those states where you're only sending the lien out by certified mail notice.
All right, thanks, Martin. So now that we're at time, I just really want to thank everyone for attending our session today. And please remember, you're going to get a quick survey. We will answer the remaining questions and we're going to send them out to those of you that have registered. We do have next up in our complex claims series, we're going to have a session on Veterans Affairs on October 30th. So you can check our website, or you'll see more information coming about that session on Veterans Affairs as we continue our complex claims segments. And again, just please take a couple of minutes and respond to the survey. We just really want your feedback so that we can make these sessions more meaningful. We know how valuable your time is. And we also are looking for additional topics for, what can we help you, what can we answer for you in what you're dealing with every day, or provide you a little bit of insight on some of those topics. So with that, thank you so much, Martin and Josh, for putting together this presentation for us. And thank you all for attending. Thank you.